I'm Pat Anderson, one of the parent advocates at Pacer Center. I want to take a couple of minutes today just to talk about ways to resolve disagreements in the special education process. Some of these examples are informal procedures, others are a little more formal. Anytime you do have a disagreement with the school, we strongly encourage that the first thing you do is bring it to the attention of the director of special education and your child's case manager. Many times we'll find those issues can be resolved through that process. Make sure your request is in writing. Documentation is very important because it does support the fact that you've identified to the district there are some issues that need to be resolved. If they don't get resolved, then you can always take a look at filing a complaint if needed. Let's just say, as an example, the district has suggested and the IEP team has agreed that special education transportation needs to be provided for your child in order to provide a safe environment to and from school. Yet when you receive your proposed IEP, you don't find it listed on there. Sometimes the situation can be resolved with just a quick phone call, speaking with your case manager, stating that, we talked about it at the team meeting, yet I don't see it on there. It may be just a slip that she missed when she or he were filling out the paperwork. And so that would be a quick way of resolving the issue. Another option might be conciliation. With the Conciliation Conference, when parents disagree with the written proposal and mark no on the parent consent form, parents have to have the opportunity to meet with this appropriate staff, whether it be just the case manager and the director of special education, at least once to try and resolve that issue. When a parent is making the decision that they disagree, most of the forms don't have a statement on it about conciliation. So when you are checking the box saying, no, I don't give permission, we also encourage that parents write on the form itself that they're requesting a conciliation conference be conducted. That conciliation conference has to be held within 10 calendar days of your request, and then within 5 business days following the end of the meeting, you should receive a summary as to what was discussed and what resolutions may have been reached. An example of that might be that you received the proposed IEP and they've decreased your math services from 5 times a week to 3 times a week, even though your child hasn't been making progress. So that would be a discussion that you would want to continue to have, and through conciliation you can reach agreements on that. Mediation is another option that both parties have to agree to participate when they're in disagreements. The Minnesota Department of Education will assign a facilitator who's going to conduct the meeting, make sure everyone feels like they're in a safe environment, make sure the communication continues, and sometimes even helps both parties look at what other options might be available, and hopefully some agreement can be reached through that process. In 2017, the Department of Education reported that 93% agreement rate was reached through the mediation process. So it can be a very successful process, especially if both parties show up with good intentions and really want to see the issues resolved. Mediation also is something that can really help build trust between parties. When agreements are reached, the mediator themselves is the person who writes up what agreements were reached. Both parties review it, and then it's signed by both parties. It does become a legal document then at that point. So mediation can be a great way to rebuild that trust and get open communications again between you and the school. Maybe as a parent you've sat through 3 or 4 IEP meetings and you're trying to get an appropriate IEP set up for your child, and it just doesn't seem to work. That might be a time that something called a facilitated team meeting can be requested by you or the school. Once again, both parties have to agree to participate in the process, and it's a request made to the Minnesota Department of Education, who again will assign a facilitator who's not going to make decisions for the team, but they're there to make sure that the IEP process moves forward and things get written and that everyone's in agreement with what's being written. The whole hope with a facilitated team meeting is, since you're writing it right there and everyone's involved in the process, that we're going to have the wording that's acceptable to everybody, appropriate services that all people agree upon, and then by the completion of it, hopefully be able to sign an IEP and get things moving forward for your child. An example of another process that you might want to try is that you know something is written in your child's IEP, yet you know it's not being followed through by the school, and you as a parent always have the right to file a complaint with the Minnesota Department of Education. That complaint needs to be in writing, and once the Department of Education receives that, they'll assign it to a complaint investigator who will make a determination as to whether or not there was a violation. That decision from the Department of Education needs to be made within 60 calendar days of the filing date. Another option that parents have is an actual due process hearing where a school district is going to have their attorney participate in, typically, and so we strongly encourage that you as a parent also have an attorney. PACER advocates are not acting as attorneys, therefore we can provide you with some resources though that you may find helpful during that process. During the year 2017, again, MDE reported that there were only 20 due process complaints for a hearing that were filed with them, and actually only 2 of them resulted in hearing officers' decisions. Minnesota has a very low rate of issues going to a due process hearing, and I think part of it is because we do have these other options that help resolve the issues at a district level and keeps it amongst the team, which can sometimes be very helpful. There are times, however, whether it's through identification of a student needing services or the services themselves, that it may be necessary to go to a hearing. If you have questions after reviewing some of the information or just need to speak with an advocate, please feel free to give us a call here at 952-838-9000 and ask to speak with an advocate. We're here to help.